Hi, my name is Daniel Tekanoff. I'm an attorney and self-published author in Fresno County, California. I wrote a book about the Article 5 Constitutional Convention Clause. I would like to present to you a summary and conclusions from the 2001 U.S. Supreme Court case Cook versus Gralike. And this is especially for state legislators dealing with Article 5 resolutions. So let me background you in what the Cook versus Gralike case was about. The state of Missouri, in their constitution, they required that any candidates for national office, for U.S. senators or for representatives running for the U.S. House, that they must support a constitutional amendment for term limits for those senators and representatives in the U.S. Congress. And if you were running for office in the state of Missouri for U.S. office and you did not support term limits, they would put a ballot designation right next to your name, right on the ballot, that says, this person does not support term limits. Basically, it's the state government telling the voters, strongly suggesting to the voters who they should vote for. And it obviously weakens that candidate's chance of being elected to office. And that was found unconstitutional by the court. And what the U.S. Supreme Court went through in terms of an analysis was, what is the nature of state power in the federal system? And it made very clear that there's only two ways for the states to have power in the national system. It must be either reserved by the 10th Amendment or delegated by the U.S. Constitution. And the court cited an old quote from Justice Joseph Story, who used to sit on the Supreme Court with Chief Justice John Marshall. And here's the quote: "The states can exercise no powers whatsoever which exclusively spring out of the existence of the national government, which the Constitution did not delegate to them." The court went on to state that the federal offices at stake arise from the Constitution itself. And when we compare this to the Article 5 Constitutional Convention delegates, they also arise from the Constitution itself. No such thing as an Article 5 Constitutional Convention of the People ever existed until Article 5 sprang into existence on the same date the U.S. Constitution did, June 21, 1788, when New Hampshire, through its State Ratification Convention of the People, ratified the new U.S. Constitution. They just beat out Virginia, who 4 days later, on June 25, ratified the U.S. Constitution in its State Ratification Convention of the People. So, if we take this analysis and we now apply it to the Article 5 Convention itself, we know that there can be no 10th Amendment reserved powers over Article 5 elections or qualifications. They must be written into Article 5 itself. Article 1 gives to state legislatures only procedural power over Article 1 elections. However, no such power is delegated to the states over the Article 5 elections or procedure. Here is the Article 5 Constitutional Convention Clause. As you see, it is missing an election clause. Here is a basic illustration of the problem. If Congress will not act, there's only one other way to get a constitutional amendment, and that is to start an Article 5 convention. But you can't start the Article 5 convention until you set up the rules and procedures, including the suffrage rules. Who will be a delegate? What is the ratio of representation? How many delegates from each state, etc. Well, the only people who have the power to do this are the people sitting in convention, and so you can't start that convention without those rules. And so you have a feedback loop. I call it the devil's loop of the American Constitution. So what do you do if you're a state legislator? As everybody's beginning to understand the gravity and nature of this problem? Stick to our foundations. How do you protect the Union? Extend the sphere of representation. That's from James Madison's Federalist No. 10. It is a basic part of our theory of free government. That means the elections are by the people, but there's another aspect to it. You have to have robust representation. many more representatives for constitutional amendment is suggested in order to secure people's respect for the rule of law, their respect for the amendments after they are ratified. The other basic aspect is to extend the sphere of amendment. Don't allow the states to run into a quagmire of having to agree ahead of time on a specific amendment. They don't have that power anyway. You have to vote for the full-powered Article 5 convention. That only means full power to deliberate and propose. It's still subject to actually a double system of check and balances. It has to go through Congress first and then out to the states. For further study, I invite you to take a look at my book, Guide to the First Article 5 Convention of the People.